Mr. Eric B. Did I pronounce the surname correctly? Yeah.
Thank you, Mr. Speaker. I would like to ask the Shadow Minister of Home Affairs, is he aware of the consequences of the repealing of the Internal Security Amendment Act of 1989, number 2 of 1989? As he has stated in his Shadow Manifesto, is the Shadow Minister aware that this will devolve the responsibility of internal security, which is currently with the Ministry of Home Affairs, from the executive to the legislative branch? Thank you.
Shadow Minister for Home Affairs.
Okay, thank you, Mr. Speaker. So it's my privilege here, and thank you, Honourable Member, for the question. The short answer I have for the Honourable Member is yes. I think that will answer your question, but of course I'll build on it. I would like to point out that the Honourable Member is mistaken. The repealing of Internal Security Amendment Act Amendment Act 1989, number 2 of 1989, will not devolve the responsibility of internal security from the executive to the legislative. Instead, it would only mean that judiciary oversight will be in place to review any decision made to detain anybody on the purpose or for the purpose of internal security. Okay, by asking this question, it shows that the Honourable Member is maybe not really sure of what's going on in the Parliament recently. So maybe for the benefit of him, I'll give a bit of short explanation of what do executive, legislative, and judiciary actually do.
Please keep it short. I assume this is common knowledge among the members of this House, what the respective branches of government are supposed to do. Please keep it short.
Okay, so thank you, Mr. Speaker. So legislative will means just passing laws, executive means exercising the law, judiciary will ensure that the law are correctly exercised. So, as I have pointed out earlier, the repealing of the Act does not devolve the responsibility of internal security to the legislative, but instead it only provides back to the decision in 1988 or 1989, I may be mistaken, of the decision by the court that objective tests can be applied to cases of internal security. Okay, so what does the Act what is the Act really all about? It inserted Section 8A Part 2 in the Internal Security Act, where I will quote, "There shall be no judicial review in any court of any act done or decision made by the President or the Minister under the provision of this Act, save in regard to any question relating to compliance with any procedural requirement of this Act governing such act or decision." Okay, in simpler terms, with this Amendment Act, the judiciary can no longer review the objective evidences that the minister may have in his opinion that warrant the detention of any particular individual, but can only review the decision to see if it has been wrong in some procedure. So in this sense, the court can no longer hear evidences on the alleged terrorist supposed bomb-making trading, if there's any, but instead they can only rule on whether the ISD handcuffed the person the wrong hand first, or maybe they have put the person into the wrong vehicle. Also, it is stated that the law governing the judiciary review shall be the same as applicable and declared in Singapore on the 13th day of July 1971, and no part of the law before, on, or after the date of any other country in the Commonwealth relating to judicial review shall apply. The very specific date, as the House might have noted, in this Act was taken to revert the scope of the ability of the judiciary to review executive application of Internal Security Act to the day Lee Mao Seng versus Ministry of Home Affairs was decided, and is to limit the possibility of applying any future case law from other legal systems similar to ours. So to fully understand why this Act really came about, we need to understand the context, okay? Pardon for the history lesson. It was in 1988, after people involved
that has to be kept short also.
Okay, thank you, Mr. Speaker. Okay, it was in 1988, after the people involved in the Marxist conspiracy were detained under Internal Security Act. Chen Shuangzi sued Minister for Home Affairs, and the court considered, in passing remark, that the executive power under ISA is reviewable. So with the common law system, the courts actually concurred with judicial opinions in similar cases elsewhere in other Commonwealth jurisdictions, that the courts can objectively review the executive exercise of discretion in the exercise of ISA. So in the court's view, without the ability to review the executive, which is what is happening now, with the Amendment Act in place, it will mean giving the executive arbitrary powers of detention without review. After the judgment, this House moved swiftly to revert the decision of the judiciary and to render the merits of detention under ISA to be unreviewable. The House passed Amendment Act, which is what I propose to repeal, and greatly expanded the power of executive to the judiciary. From now onwards, or from then onwards, nobody who is detained under the Internal Security Act can appeal to the court on the merits that you are actually not a terrorist. You can only argue that maybe they caught you when you're in the toilet, which is against their procedure, or maybe they put you in the wrong vehicle, which is against their procedure. Nobody except the minister will have to justify what are the reasons, what are the merits that you have, that you are to be considered as a threat to national security. So I hope I have answered the question by the honourable member. Thank you.
Thank you, Shadow Minister. Mr. Tan Zhongxian.
Thank you, Mr. Speaker. I would like to ask the Prime Minister, in view of the recent case of possible corruption, and allegations of personal misconduct of the ex-head of SCDF and the Central Narcotic Bureau, CNB, I would like the Prime Minister, the head of Civil Service, and the head of CPIB to clarify a few points. On corruption in the civil service, is this a sign of things to come with regards to the prevalence of corruption in the civil service? Is the CPIB cracking down on more possible occurrence of conflict of interest in the civil service? If so, how can CPIB do it? And to what extent will they look into? Will it just be limited to recent years, top-level tenders, or even longer period and all levels of awarding of government contract? On process of awarding government contract in the civil service, is there a systematic failure in the bureaucratic process of determining the best tender for a particular contract? Is there a need to review, relook, and rethink the whole system of requesting for tender and quotation for a government contract? If there's a need, how will it be done? If there's nothing wrong with the process, why is it possible that so much power to be concentrated in one man to the extent that they're able to effect the decision in their favor? On CPIB and possible conflict of interest, how will the CPIB, which can be seen to have a conflict of interest by being under the Prime Minister's office, should such alleged corruption cases extend to the ministerial level, be accountable to the public? How can independent and transparent investigation be carried out in the case of alleged corruption on the ministerial level to ensure accountability to the public? On conduct of personnel in the civil service, should it be business as usual in the civil service? Or should there be fundamental rethink in how top personnel in civil service conduct themselves? Should there be a stricter code of conduct to govern the civil servants? It has also been alleged that the head of CNB was previously involved in some personal misconduct in his previous post, but he was transferred to CNB. Is this an anomaly or the way that civil service and the executive conduct itself by switching people around accused of misconduct in the top echelons of the administration? Should there be a stricter internal disciplinary mechanism to melt up punishment to civil servants who do not live up to the expectations of public administrations? Thank you.
The Prime Minister.